Hi, this is Cindy Simpson with the Yaeger CPA Review, and this is our March 2012 update that we're doing to our 2011 BEC Home Study and Cram Program and 2012 BEC Home Study and Cram Program to update you for the new rules that the SEC has published for whistleblower. Okay, now what has happened is that we're going to do a video for you, and in this video you're going to need two materials, and the two materials you're going to need are, first, there's going to be a one-page PDF file. This was written by our author, and at the top it says Whistleblower March 2012. This came from our author. All I did was put a title on it, Whistleblower March 2012, and you can think of that as being a summary. Also, the other material you're going to use is you're going to use an SEC for the Securities Exchange Commission. You're going to use one of their news releases or press releases. It is found at their website, and their website, the address for it will be http://www.sec.gov/news/press/2011/116.htm. And this is also going to be provided for you in a link. Okay, so you're going to need these two things. Both of them will be provided for you in a link. You need both these things because I'm going to be referring to them in this video. Okay, so please go and get these things and print them out, and I'll refer to them in the video. Now, to give you some context, what happened is that on May 25th of 2011, the Securities Exchange Commission, which is the SEC, they did adopt final rules to establish their whistleblower program. And this was part of Section 922 of the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. Now, the rules became effective on August the 12th, 2011, but then, it takes about 6 months for it to be eligible for testing on the CPA exam. This would put it in mid-February of 2012, so I think that this topic could be tested on the exam beginning with April of 2012 in that testing window. So it's effective for April 1st, 2012 on the exam. Okay? Now, to give you some additional context in your textbook, I do believe that whistleblowers could be another type of monitoring device, and it's a device for monitoring management's behavior. Now, if you happen to have the 2011 Wiley textbook, the monitoring devices in the 2011 Wiley BEC textbook are discussed in Module 41 on pages 38 through 41, as well as in the handout we did for our mid-year update in 2011. Now, if you happen to have the 2012 Wiley BEC textbook, the monitoring devices are found in Module 40 on pages 36 through 41. So basically what a whistleblower is that they're another type of monitoring device for monitoring management behavior. So that's where this information would fit in your textbook. Okay? Now, also, I think that the SEC's Office of the Whistleblower, they now have something called the Office of the Whistleblower in the SEC. I think that this could be another part of the SEC, and you could be familiar with it. This is in addition to the three other offices that I mentioned to you about the SEC, and that was the Division of Corporate Finance, the Division of Enforcement, and the Office of the Chief Accountant. So now also you'd have to know a little bit about the Office of the Whistleblower. And I think that the Office of the Whistleblower is going to help handle any whistleblower tips and complaints. And I think they'll also provide guidance to the Enforcement Division staff in the SEC. And I think that the Office of the Whistleblower will help the SEC determine the size of the awards for each whistleblower. And they're also going to assist whistleblowers by promoting the program, providing guidance, and answering questions about the program. Okay? Now, what I'm going to do is first I'm going to refer, I'm going to be going back and forth between the SEC press release and the one-page PDF file that says whistleblower, March 2012 at the top. But first I want to tell you then what is the definition of a whistleblower. And if you turn to the SEC press release, under the caption that says rule requirements, there's a definition there for a whistleblower. So let's go over that definition. And it says that a whistleblower, so they're talking about the final rules, and these are the final rules that were issued by the SEC. All right. And the final rules define a whistleblower as a person who provides information to the SEC relating to a possible violation of the securities laws that has occurred, is going, or is about to occur. By the way, I also want to mention to you that a whistleblower must be an individual, okay? A company or another entity is not eligible to be a whistleblower. Once again, to be a whistleblower, you have to be an individual. A company or another entity is not eligible to be a whistleblower. So I wanted to mention that to you, okay? Now, let's go back then, since we've gone over then what is a definition of a whistleblower. Let's go back to the one-page PDF file that says whistleblower, March 2012 at the top, okay? And let's take a look at that one-page PDF file. And we can think about this as being sort of like an outline, and then I'll point out to you some additional details, okay? Now, at the top, it says the SEC rules related to Regulation 21F of the Dodd-Frank Act eligible for testing in the second quarter of 2002, which would be April 1st of 2012. Sorry, 2012, not 2002, 2012. Now, the Dodd-Frank Act provides that the SEC will pay awards to whistleblowers for providing information about violations of securities acts that result in aggregate monetary sanctions in excess of $1 million. The Act and related rules provide that A whistleblower is eligible to receive 10 to 30% of the monetary sanction if the information is derived from independent knowledge or analysis of the whistleblower and not known to the government from any other source. B, tips can be made anonymously, such as through an attorney, with the whistleblower only being identified to the SEC after determination that an award will be given. Letter C, a broad group of individuals are eligible, including employees, customers, and suppliers. Individuals that are generally excluded from eligibility include, number 1, officers, directors, trustees, and partners of an entity when those individuals learned of the information about the misconduct from another person or in connection with the company's processes for identifying potentially illegal conduct. 2, employees whose main job functions involve compliance or internal audit, or persons who are employed by a firm hired to perform an audit or compliance functions or to investigate possible violations of the law. And 3, employees of public accounting firms that are performing an engagement required by the securities laws, such as, auditing that SEC registrant company. Okay, so that's sort of like a summary for you. But what I would like to do is turn to the SEC news release, and I want to go over some of the concepts. It says key concepts, and it says avoiding unintended consequences. Because what we have on our one-page PDF is a nice summary, but I'd like to go through some additional details that are found on the press release. Now, if you take a look under key concepts, avoiding unintended consequences, this is on the SEC news release. It says certain people generally will not be considered for whistleblower awards under the final rules. And these people include people who have a pre-existing legal or contractual duty to report their information to the SEC, attorneys, this includes the in-house counsel who attempt to use information obtained from client engagements to make whistleblower claims for themselves, unless disclosure of the information is permitted under an SEC rules or state bar rules. Also, who would not be considered? People who obtain the information by means or in a manner that is determined by a U.S. court to violate federal or state criminal laws. So if you got the information in an illegal way, then you're not eligible for an award. All right, next one. Foreign government officials. I think that's important too, foreign government officials. And then here they give the list: officers, directors, trustees, or partners of an entity who are informed by another person, such as an employee, of allegations of misconduct, or who learn the information in connection with the entity's processes for identifying, reporting, and addressing possible violations of law, such as through the company hotline. So if you're an employee and you're manning the company hotline, right, you would be excluded from being a whistleblower, all right? Compliance and internal audit personnel, so you work in internal auditing. Um, Public accountants working on SEC engagements if the information relates to violations by the engagement client. Okay, so these in general, okay, these people would not be considered for whistleblower awards under the SEC rules. Now, of course, then there are exceptions. So let's go over the exceptions. However, in certain circumstances, compliance and internal audit personnel, as well as public accountants, could become whistleblowers when the whistleblower believes disclosure may prevent substantial injury to the financial interest or property of the entity or investors. The whistleblower believes the entity is engaging in conduct that will impede an investigation. All right, like let's just say they start shredding some important papers. Okay, and then the third bullet: at least 120 days have elapsed since the whistleblower reported the information to his or her supervisor or the entity's audit committee, chief legal officer, chief compliance officer, or at least 120 days have elapsed since the whistleblower received the information if the whistleblower received it under circumstances indicating that these people are already aware of the information. Certain other people, such as employees of certain agencies, like government agencies, and people who are criminally convicted in connection with the conduct, these people are already excluded under the Dodd-Frank Act. Now, under the final rules, the Commission also will not pay culpable, that means guilty, whistleblowers awards that are based upon either the monetary sanctions that such culpable individuals themselves pay in the resulting SEC sanction. So no fair getting an award based on whatever fines and penalties you have to pay, right? The monetary sanctions paid by the entities whose liability is based substantially on conduct that the whistleblower directed, planned, or initiated. And then finally, the purpose of all these provisions is just to prevent the wrongdoers from benefiting by, in effect, blowing the whistle on themselves and benefiting from their own acts. Okay, all right. So those were some additional details that I wanted you to know for who was not eligible. All right, and then the exceptions. All right. Now the next thing that I want to do is let's just take a look. Okay, on back to the one-page PDF file, the very last item on the one-page PDF file, which is letter D. And letter D on the one-page PDF file says whistleblowers are encouraged to report the information through the normal internal corporate governance system of the company by an indication that such action may increase the amount of the award. So you're encouraged then to report it through your internal corporate governance system, and this may actually increase the amount of your award. Okay, now let's go back to the SEC news release. Now in the SEC news release, they have a caption, okay, under where I left off, for who is excluded from getting an award, and then the exceptions. They have another caption underneath that says supporting internal compliance programs. So let's just go over that. This is what's so additional details on, that summary that was provided on the one-page PDF. So supporting internal compliance programs. The final rules do not require the employee whistleblowers to report violations internally in order to qualify it for an award. However, the rules strengthen incentives that had been proposed and add certain additional incentives intended, and this is intended to encourage employees to use their own company's internal compliance programs whenever it's appropriate to do so, right? For instance, the rules make a whistleblower eligible for an award if the whistleblower reports internally and the company informs the SEC about the violations. Treat an employee as a whistleblower under the SEC program as of the date the employee reports the information internally, as long as the employee provides the same information to the SEC within 120 days. Through this provision, employees are able to report their information internally first, and this can preserve their place in line, okay, for a possible award from the SEC, all right? And also, the rules do provide that a whistleblower's voluntary participation in an entity's internal compliance and reporting system is a factor that could increase the amount of an award, and that the whistleblower's interference with the internal compliance reporting is a factor that could decrease the amount of the award. So that's why it gives a little bit more additional detail. So your behavior could actually increase your award, and your behavior, if you impede them, could actually decrease the award, okay? And then Finally, right above the supporting internal compliance programs, what we just went over on the SEC press release, right above it, it says clarifying anti-retaliation protection. I think this is important because you cannot retaliate against the whistleblower. So let's just look over that on the SEC news release. It says clarifying anti-retaliation protection. Under the rules, a whistleblower who provides information to the commission is protected from employment retaliation if the whistleblower possesses a reasonable belief that the information he or she is providing relates to a possible securities law violation that has occurred, is ongoing, or is about to occur. In addition, the rules make it unlawful for anyone to interfere with a whistleblower's efforts to communicate with the SEC, including threatening to enforce a confidentiality agreement. Okay, so they make it illegal then. All right, unlawful for anyone to interfere with a whistleblower's efforts to contact the SEC about these acts. Okay, so I just wanted to point that out to you, that you're not supposed to retaliate against the whistleblower. All right, now how could they test this information on the CPA exam? And remember, we think this could be effective for the exam beginning April 1st of 2012. Well, I think first of all, this could be a written communication, okay? They could ask you for what is the definition of a whistleblower. They could ask you who cannot be a whistleblower, and then what are the exceptions of ordinarily who could not, but then what are the exceptions to that? And then finally, you should know that there are rules that do prohibit retaliation against the whistleblowers. And that's how I think that they could ask it. All right, that's all I have for you. Thanks for your attention to our March 2012 update to our 2011 BEC CRAM and Home Study programs and our 2012 BEC CRAM and Home Study programs. Bye-bye.